All right. Good afternoon, everyone. My name is Michelle Plantatakis, and I'm excited to be presenting this webinar alongside my colleague, Ethan.
Hi, everyone. My name is Ethan Edwards. I'm a junior associate at SBA Law. Thanks everyone for being here today.
So we are Strigberger Brown Armstrong. We're an insurance defense firm with 3 offices across Toronto, Kitchener, and London. Today's webinar, titled Payback Time, Addressing Overpaid Benefits, will cover key insights into handling claims where benefits have been overpaid, and more importantly, how to get that money back. First off, we really appreciate you all taking the time to tune in for this session. We hope to share some valuable information with you and answer any questions you may have at the end. If you do have questions at the end, please do use the Q&A button on the bottom of your screen. Also, this webinar will be recorded, so if you want to watch it again, you can pull it up on our website in a couple of days. Feel free to send a link to a colleague or friend. And also, if anyone would like a copy of this slide deck, mine and Ethan's email addresses will be provided at the end of the slides, and you can email either of us to get a copy of those. So without further ado, let's dive right in. So today we're looking at 2 main things. We'll look at, first off, what is an overpayment, or in what kinds of situations can an overpayment arise? And then how does an insurer go about seeking repayment of those overpaid benefits? Next slide, please, Ethan. So questions about repayment come up quite often in our practice. So before we start, let's actually see what everyone thinks about some sample scenarios here. We're going to run a poll. And for each scenario, we want you to indicate yes or no if you think recovery or repayment is possible. Okay, so let's start the first scenario. So in this first example, IRBs are paid to someone who didn't tell their insurer that they had moved to a province where the insurer doesn't provide coverage. Do you think, yes or no, that this is recoverable? All right, we got a little bit more no, saying no, 62%, 38% are saying yes. Okay, that's good to keep in mind. I will go over the answers shortly. Let's run the next scenario. So next one, IRBs are paid to someone in respect of a staged accident. Are those recoverable or not? Yes or no? All right, 95% of you are saying yes, 5% no. Interesting. Let's go with the last one. Surveillance fees are costs of insurers' examinations in respect of someone who said they were involved in an accident but weren't actually. Yes or no, are these recoverable? Okay, so 26% said yes, 74% of you said no. Now let's look at what the answers actually are. And we get those answers from section 52 of the SABS, which is here on the slide. I'm not going to read it for you, but I'll go through each of the subsections because it does lay out the 3 typical scenarios in which overpayments can arise and where insurers can seek repayment. So the first is basically any benefit that was paid essentially by mistake. So whether it's the error on the part of the insurer or the claimant or anyone else, or a benefit that was paid as a result of a material or a willful misrepresentation or fraud. So now think back to the example of the surveillance fees or, insurer's examination fees, other adjusting fees that were paid in respect of the claimant who wasn't actually involved in the accident. Those fees can actually not be recovered because they weren't benefits. So good job to, I think it was 74% who said no on this one. They're not recoverable because these fees are not benefits paid to the claimant. But think of the other example where there's IRBs being paid to someone as a result of a staged accident. Those are recoverable because IRBs are a benefit and they were paid as a result of fraud. The next subsection B talks about overpayments that arise where specifically either an IRB or a non-earner benefit, an NEB, was paid to a person who was disqualified as a result of a Section 31 exclusion. So think again to the example that we just went over of the person receiving IRBs who hadn't told their insurer that they had moved. So in that case, the IRBs are recoverable because the exclusion at Section 31 sub B of the SABS would apply since the insured failed to notify their insurer of a change in risk. The final situation where overpayment can arise is where where income replacement benefits, non-earner benefits, caregiver benefits, or any benefit under Part 4, so say visitors expenses. If any of these benefits were paid out but could have been reduced by amounts that are deductible under the SABS, then the overpaid amount in those cases can also be recovered. A common example we see of this is where a claimant is, for say, receiving IRBs, they return to work in some capacity, and their post-accident employment income hasn't been accounted for in the calculation of their IRBs. So that overpayment can also be recovered. Next slide, please. So now that we know when or in what situations an insurer can seek repayment, let's turn to how exactly an insurer seeks that repayment. Enter the notice requirement. So Section 52 sub 2 now tells us that in order to seek repayment, an insurer needs to provide notice of the amount to be repaid. There's two key things I want you to notice, pun intended, about the language used in this section. And the first is that it says the insurer shall give notice. This is mandatory language. It's a mandatory requirement. So no notice, no repayment. Second, it says if a person is liable to repay, the insurer shall give the person notice. So this means you're directing your notice letter to the person, usually the claimant, who has to repay the benefit. Section 52 sub 2 is also important because it tells us that in a case where an overpaid IRB or caregiver benefit is still being paid when notice is being given, the insurer may give notice if it wants to recollect or if it wants to collect the repayment this way, that it's going to reduce future payments by up to 20% of the original amount being received. And they can continue doing that on all future payments until the full amount of the overpaid benefit is recovered. But there is a caveat to it all because, of course, providing notice isn't enough. As with most things insurance related, there's a deadline to providing the notice. That's where Section 52 sub 3 comes in. And that tells us that if notice isn't given within 12 months after the amount to be repaid was originally paid, you are barred from seeking repayment. There's also an exception to that, though. So for cases where the overpayment was a result of misrep or fraud, in those cases, notice still should be given, but the 12-month deadline doesn't apply. So I'm going to turn it over to Ethan now to tell us more about the history of Section 52.
Okay, thanks, Michelle. So yeah, I'm going to take a quick look at some of the legislative history surrounding overpayment and the SABs. And we can see that even in the earlier versions of the SABs, that overpayment has been a consistent component and has been available to insureds in the three scenarios that Michelle described previously when she was looking over the statutes themselves. Despite this historically being available to insurers, if we look at the case law itself, we see that arbitrators and judges have typically interpreted this very narrowly in the past. If you look at the Superior Court case, State Farm and Kong, Justice Kennedy reviewed the case law existing at the time and found that overpayment was only available to insurers when the insured person had contributed to the overpayment in some material way. So in essence, they required some sort of bad faith through either recklessness or intention on the part of the insured before they would allow overpayment. So this was the case for overpayment in the SABS until we got the 1996 version of the SABS, which introduced the notice requirements. And we can see from the case law that followed this inclusion that this sort of acted to balance the fairness by allowing the insurer access to the overpayment remedy so long as they complied with the notice requirements to, in essence, give the insured a heads up. One of the first cases that looked at this was a FISCO case from 2003 called Trottier. In that case, the claimant was being paid IRBs while still having access to LTD benefits. After they were paid for the pre-104 IRBs, the insured then received their payment of LTD benefits. And in this, it was paid retroactively for the period which included their payments for IRBs. The insured acted in good faith and notified the insurer relatively quickly, about a month after receiving the payment. So this case was absent of that bad insurer requirement that had previously been required. In this case, the fiscal director delegate found that the insurer had given notice and was therefore entitled to the overpayment. However, it was only required to the overpaid amounts for the 12-month period prior to the notice date. And another case that looks a little bit more closely at that 12-month period is a case called Prize and Economical. Another FISCO case. This case affirmed the approach that was taken in Trottier. The case surrounded an arbitrator's decision that attempted to broaden the interpretation of notice, such that as long as notice was given after 12 months after the overpayment had been received, the insurer was entitled to recuperate any payments that were deductible. Now, on appeal, the director delegate overturned that decision in favor of a more narrow approach and held that insurers are only entitled to recover overpaid amounts in the 12-month period prior to the notice demanding repayment. So even if there are overpayments outside that 12-month period, the insurer isn't entitled to it based on the statute. And so now I'll pass it back to Michelle to take a more closer look at the notice requirements.
Thanks, Ethan. So from what we've seen so far, the timing of the notice is really important. The SABS tells us as much. What the SABs don't tell us, though, is that the content of the notice is actually also really important. Because even if notice is given within the required 12 months, it might still not be valid notice. The case law has weighed in on what valid notice is, beginning with Nechtel versus RSA. In that case, the insurer was seeking repayment of overpaid caregiver benefits, which arose as a result of a daycare subsidy payment that the claimant was receiving post-accident, and that wasn't deducted from her caregiver benefit. In considering whether RSA's notice to the claimant was valid, the arbitrator laid out the basic information that a notice for repayment should contain. So it should contain the name of the benefit that was overpaid, the correct weekly, monthly, or lump sum amount of the overpaid benefit, the time span during which the benefit was paid and the insurer is now seeking to be repaid, and a calculation of the repayment to be repaid, or that's being claimed. Ultimately, the notice in this case was not considered valid. It lacked this basic information, so the insurer in this case was not entitled to repayment. Next slide, please. The notice requirements set out in Nechtel were affirmed by the Superior Court of Justice in 2016 in the case of Intact versus Marianayam. So once again, we see an emphasis on, the type of benefit being claimed, the period for which the repayment is being sought, and the amount of repayment being sought as well. But Marianayam is also important for setting out the standard to which insurers' notices are held. So, in determining whether a notice letter is valid, Justice Perel in this case held that a standard of substantial correctness should be used. What this meant is that a notice didn't need to be perfectly correct, but it should be substantially correct. So, Ethan's going to tell us now about how that substantially correct standard has evolved since then.
Thanks, Michelle. So the standard of substantially correct isn't a definition that's defined in the SABS. It comes from case law, so therefore we have to look at case law to figure out how we interpret it. And I'm going to go over a couple cases that look at that. The first one is Economical and VS, which is a LAT case from 2019. In this case, the claimant argued that a notice of overpayment was invalid because the first notice that they received contained an error in the calculations provided for the overpayment that had to then subsequently be corrected by a second notice. Now, it's notable that the first notice had to be corrected by the second notice only after updated financial information had been ordered by the LAT. Additionally, the adjudicator noted that this particular case was complex based on the fact that the insured was self-employed, and the claim also included deductions for underpayments in IRB. So it was a particularly complex case. The applicant tried to argue that the first notice was premature, absent an accounting report and a determination for IRB quantum, but the adjudicator ultimately disagreed. He found that the STABs only require that the notice be substantially correct and not perfectly correct. The first notice did comply with those requirements because it was substantially correct based on the information available at the time. So overall, it was found that it was substantially correct. Two other cases that I wanted to point to that illustrate that substantially correct isn't a carte blanche for insurers and that it can't be stretched too far. The first one is called Kula Veerasingham. This is a case where the insurer sought judicial review at the divisional court based on a FISCO decision that had found several of its notice letters to not be substantially correct. It's important to note that each of these notice letters had some sort of issue with it. For example, one of them was seeking repayment for 13 and a half months, contrary to the notice requirement. So each notice letter had something that was wrong. Ultimately, the divisional court found to sustain the FISCO decision, citing the director delegate's observation that close enough was not substantially correct. The court rejected arguments that valid notice could be created out of multiple notices and backdating, and found that overall these errors in total invalidated the notice. So in essence, an insurer cannot piecemeal together a valid notice from past incomplete or incorrect notices. Another case is CQ in Pembridge. In this case, the insurer sought overpayment because it had discovered that after making payments that it had mistakenly increased the claimant's med rehab limits beyond the purchased optional benefits. The notice letter in this case only indicated that an error had been made and that IRBs were being reduced, but it had no information as to what the actual error was, and there was no information as to what time period was being disputed. So overall, the adjudicator in that case found that the notice of overpayment was not in plain and clear language, and so therefore it was not substantially correct. One last case I want to touch on briefly is called Unica and Jaya Bellasingham. This is a case where the claimant alleged that the notice letter did not comply with the notice requirements that were described in Mariana Yagam. Specifically, it cited that there was no calculations provided as to the overpayment and that the timeline in the notice was not clear. The adjudicator in this case disagreed that the notice actually required specific calculations to be included and found that the SABs only required 3 of the other criteria from Marianam, specifically the identification, the period, and the amount sought for repayment as permitted by statute. So in terms of the timeline, the adjudicator looked at the total contents of the letter and found that it could have been clearer presented to the claimant, but overall, there was sufficient information such to alert the claimant of the timeline in dispute. So with that, I'm going to pass it back to Michelle, and she's going to explain our activity in terms of ABCs of notice requirements.
Great, thanks, Ethan. So we're nearing the end of our presentation, and we thought we'd conclude with some examples. We'll give some sample notice letters, and we want you to put your knowledge to the test. See if you can tell which ones are proper valid notice and which ones aren't. Before we get into them, though, let's keep what we call the ABCs of notice requirements in mind. And again, we've gone through these, I think, so much already. So hopefully you already have them mastered, but remember these ABCs. A, identify the type of benefit that's been overpaid and that you're seeking repayment for. The letter has to state, for example, that you're seeking repayment of IRBs or NEBs or visitors expenses or whatever the case may be. B, identify the payment period for which you seek repayment. Be specific, use dates, use full dates. For example, the benefit that was paid from January 14th, 2024 to April 22nd, 2024. Be specific. And finally, again, C, identify the amount of repayment you're seeking. And most importantly, show your calculations for that amount. So we can move to the next slide, please, and take a look at our first sample notice letter. So I'll read it out and then we'll start a poll for it to see whether you think it's a valid notice letter or not. So it says, "Dear Mrs. Lawyer, we acknowledge and confirm receipt of your correspondence dated November 22nd, 2007, relating to the resolving of Mr. Claimant's LTD action against Collateral Benefits Group. Please be advised that we have reviewed Mr. Claimant's file and confirmed that he continues to be eligible for his weekly benefit. However, as he is currently receiving a benefit from Collateral Benefits Group that exceeds the SABS weekly maximum of $400, we're unable to make any further top-up payments at this time. As such, we're advising that an overpayment was made with respect to Mr. Claimant's weekly benefit in the amount of $68,800. Please contact the undersigned to arrange repayment." So let's pull up that poll, please, and tell us, is this a valid notice letter? Yes or no? All right, so 4% of you, 2 people said yes, 54 said no. 54 of you are correct. So A is not met. Remember, the type of benefit, we see nowhere in this notice letter where it says the type of benefit that they're seeking to be repaid. It likely is income replacement benefits, but it doesn't say so in the letter, so that's not met. B, it doesn't tell us the period of payment that the repayment's being sought for. So that's not met either. And then C, fine, it does say that $68,800 is being sought. We have no idea, though, how the insurer got to that amount. So there's no calculations. Arguably, this is not a valid notice letter. Next slide, please, Ethan. You can take over this one.
Thanks, Michelle. Okay, so I'm going to read out this one, same as before, just to give some people time to absorb. So, dear Miss Claimant, in connection with injury sustained in the above noted accident, we have paid you income replacement benefits as you have suffered a substantial inability to perform the essential tasks of your employment as a result of the accident. We understand that you have now resumed your pre-accident employment duties effective September 21st, 2018. Therefore, you are no longer eligible to receive an income replacement benefit as you have discontinued your benefit effective December 15th, 2018. As we were not aware that you have returned to work, the income replacement benefit was paid up to December 15th, 2018. Therefore, there is an overpayment of $4,800. All right, so I'll ask to have this poll brought up. Is this a valid notice letter? Okay, so a pretty 50-50, well, almost a 50-50 split. I will say in this case that this was found to be a valid notice header. So the yeses are correct on this one. So if we look through our ABCs again, so this letter does state that IRBs are an issue. Now, this one's actually interesting. So remember for B, we have to identify the time period. This is an actual letter from one of the cases that I mentioned, Utica Insurance and J. Abella Singham. So in this case, the adjudicator said that the time period could have been clearer, but there was sufficient information overall to give the period the overpayment was being sought for. And finally, C, it does state the amount, and this amount would be allowed under the statute for the 12-month period. Okay. And we'll pass off to the next one now.
All right, so our final notice letter. Dear Mr. Claimant, through review of your file, we have discovered your income replacement benefit was overpaid. You are receiving a weekly income replacement benefit under Part 2 of the Statutory Accident Benefit Schedule in the amount of $400 per week from March 10th, 2012 to January 19th, 2015. We have recalculated your benefits based on an explanation of benefits from Great West Life, dated July 8th, 2015, and an explanation of benefits from Great West Life dated July 10, 2015. The amount you should have received was $400 per week from March 10, 2012 to June 29, 2013, and then $103.53 per week from June 30th, 2013 to January 19, 2015. The total amount of income replacement benefit you received was $59,527.50. The total amount you should have received was $35,672.50. This has led to an overpayment totaling $23,527.50 in accordance with Section 2. Section 52 of the Statutory Accident Benefit Schedule. We are requesting you repay the amount in full within 21 days from the date of this letter. So let's pull up that poll. Is this a valid notice letter? All right, so most of you, 77% of you say it is valid, and then 23% of you say it's not. The minority in this case is right. This is not a valid notice letter. So when we think back to our ABCs again of notice requirements, A is met. Yes, it states that the type of benefit being sought for repayment. It states income replacement benefits. Perfect. B, the time period, it does. It gives a breakdown of the dates, you know, X amount, $400 from March 10, 2012 to June 29, 2013, and then $103.53 from June 3rd, 2013 to January 19, 2015. So it's really specific with the dates that's met as well. But C isn't met because it's seeking an amount that's beyond the 12 months. So the amount is not correct in this case. As you can see, they're looking for benefit or for overpayment going back to 2013, and presumably we're now in 2015 with this letter. So C is not met in this case, and therefore it's not a valid notice letter. So we can move on to questions. Let's please feel free to use our Q&A. I see a couple questions here already. Okay, so this is actually a question we get quite a bit. If we can't get our costs for IEs or engineering costs or whatnot back in fraud files, what can we do to get the money back if we can't use Section 52? Good question. Again, we get this a lot, especially on cases where there's staged accidents. The lot, again, there's been lots of case law. We're happy to send that to you. Actually, if you'd like to see the case law, I can think of a handful of cases that pertain to this, but the lot almost certainly will not order you repayment for those kinds of expenses. What you can do, though, I mean, small claims court, superior court actions, those are an avenue that you can pursue. Oh, and we are at time. Look, time flies when you're having fun. So we're actually going to end the webinar for today. Please feel free to reach out to us. Our emails are there. Um, you can let us know if you have any questions. You can ask us for the slide deck if you'd like it. And thank you so much for joining us. It's been our absolute pleasure.
Thank
Enjoy
you
your
very much,
afternoon,
everyone.
everyone.